Hi, I'm Phil Brandt, President and CEO of AIM Employers Association, and welcome to a special edition of This Week at Work.
Welcome to This Week at Work, the only show to pack workplace news, practical HR solutions, and timely insights into every 30-minute episode. From the latest rulings in the courtroom to the strategies unfolding in the boardroom, and from real conversations taking place on the front lines to spotlighting what similar companies are doing about the challenges they face. This Week at Work brings you the conversations that matter most to HR professionals and business leaders like you. Brought to you by AIM Employers Association and Ogletree Deacons, live every Thursday morning. This is your opportunity to connect with their experts and ask your burning questions. So what's keeping you up at night? Let's face it together now on This Week at Work.
Today we are here to discuss the recent executive orders signed by President Donald Trump on January 21st, 2025, which revoked several previous orders and memorandums related to affirmative action and DE&I policies. If you're feeling a little uncertain, conflicted, or overwhelmed by these changes, you're not alone. With affirmative action shaping policies for over 60 years and DE&I initiatives playing a major role in recent years, those feelings are to be expected. Over the past several weeks, I've spoke with many business leaders who have shared a sense of inner conflict, balancing legal compliance, workplace culture, long-standing diversity efforts, and their own personal views of what's right and what's wrong and what's best for our country. Today, we are going to discuss what is happening within the frameworks of the law and bring some practical application and guidance. Joining me today is my partner in crime on This Week at Work, Burt Garland. Burt is an attorney and shareholder with the St. Louis office of Ogletree Deacons. Good morning, Burt.
Good morning. Easy for you to say,
Blah,
Phil.
blah, blah. Yeah. And normally we're doing this at 7:30, not 8:30. All right. Also, we have attorney and managing shareholder from the Nashville office and also a guest of the program in the past. And that is Luther Wright Jr. Good morning, Luther.
Good morning. Glad to be back.
And always a fan favorite. You've seen him on stage at many of our events before, and that is thought leader Fred Falker. Good morning, Fred.
Good morning, all.
All right.
Good morning.
Well, I'm going to get my tongue untied here, and we're going to get going. But I think it's best if we start with a little bit of a historical look back to understand how we got to where we are today. That always frames an understanding. And if we look back into the 1960s and the civil rights movement, along with the Executive Order 11246 that was signed into action, establishing affirmative action as an objective or goal for the government, I think it's important to understand maybe what was going on at that time and what were the goals of those policies. And I'll throw that to the panel.
So let me even step back just a little bit further than that, Phil. Let me kind of set the legal framework, and then I think we can open it up to have a few people really chat about what the policy goals were. And I'm going to go back centuries and talk about the 14th Amendment to the U.S. Constitution. And under the 14th Amendment to the U.S. Constitution, that's where the Due Process Clause is contained. But there's also another very important part of the 14th Amendment, and it has what's in there called the Equal Protection Clause. And I put up on the screen, or Nick has put up on the screen, a snippet from the 14th Amendment, and it specifically says, no state shall make or enforce any law which shall, read through the black part there, deny to any person within its jurisdiction the equal protection of the laws. And so the 14th Amendment has been used over the centuries to basically say that no state, including or government actor, the federal government, cannot discriminate against people. Everybody has equal protection under the law. And so the 14th Amendment has been used over time to say we cannot discriminate on the basis of race, sex, age, whatever category, no
Why are we
person.
here talking today?
Yeah, well, that's why we'll talk about the policy
All right.
goals of this. So that's where the foundation of it begins. And of course, the 14th Amendment is hugely important in that role. And then we move on several hundred years, I guess, or at least 100 plus years, and we move to 1964. And that's where we get to the Civil Rights Act of 1964. And that contained, that is Title VII. And under Title VII, which is the primary federal law prohibiting discrimination in the workplace, it's very important that we understand the language of Title VII. And Nick, you can advance to the next slide so that everybody can read this and see the foundation of it. It is an unlawful employment practice for an employer to fail or refuse to hire or to discharge an individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment. And this is very important, because of such individuals' race, color, religion, sex, or national origin. There's some more language in Title VII that I've included. There's some language I've excluded because I don't think it's relevant to our discussion. But then it goes on and it talks about seniority or merit systems. And it says that seniority or merit systems are lawful. And that's going to become a significant part of our conversation today. And so what Title VII essentially says is that employers, to use the phrase, need to make employment-related decisions about their employees basically in a colorblind or sex-blind or religion-blind or national origin-blind manner. You may not use those criteria, those protected categories, to make determinations about employees. And so that's the way the law was back in 1964. That's the way it exists today. Coming out of the Title VII, there was also the executive order, Phil, that you mentioned before, signed by President Lyndon Johnson. And he signed that. Every president, going back to George Washington, has issued at least one executive order. Nick, if you could advance a slide or two. And so every president has issued at least one executive order. And President Johnson issued an executive order also in 1964, I believe, that established affirmative action for federal contractors. And that was a very significant development. And I'd love to turn it over to Luther, especially because we've chatted about this already. What was really the policy goal? What was the federal government's role? Why was affirmative action established?
Yeah, and I think that becomes a really important part of this conversation. And I'm glad that you started with the 14th Amendment. When you think about it specifically in terms of African Americans, the first problem with the 14th Amendment was African American folks were not recognized as people, right? So then the 14th Amendment didn't originally apply. You're not a person. That's the Dred Scott decision.
Right here in St. Louis, right, by the way,
and then
the old courthouse downtown.
And then you get to cases like Plessy versus Ferguson, which says, okay, you're getting equal protection, but it's separate. And so then you have this doctrine of separate but equal. And then you get to Title VII in 1964. And I think the reason that we are here and we're having this conversation is because we're wrestling with, okay, we have not always lived up as a nation to the goals of the 14th Amendment. We allowed the doctrine of separate but equal to impact how people were educated. You had separate units in the military, and this notion of having equality, but it was separate, and we had this segregated society is really what Title VII was trying to eradicate, especially in terms of employment. And so now you're looking at with affirmative action, okay, we've said this is the goal. Now we've got to do something to make sure that these things actually happen. And that's where you see Lyndon Johnson's executive order. And then President Nixon in particular, folks don't always talk about that, really sort of started to codify this idea of you're going to have to take steps. The federal government has played a role historically in not protecting people consistent with the Constitution. Now the federal government has to affirmatively do something to eradicate the wrongs of the past. And that's how we get to affirmative action.
The federal government sanctioned, it was authorized, it was
Absolutely.
legalized
Absolutely.
discrimination prior to certainly the 14th Amendment, but then as you discussed the history of it, it didn't apply to Black people initially, and then it didn't, and then as it developed, separate but equal. And so when we get to the idea of meritocracy, what was referred to, or when you hear people say we need to get back to a meritocracy, that means one thing for Black people, especially going back to the 60s versus white people, because it's sort of separate but equal. It's the Blacks weren't necessarily part of the meritocracy. I think we can all agree what a meritocracy means going forward. It means merit for everyone, but it needs to be applied to everyone.
Right. And I think that becomes the conversation then, as we've talked about before, being the child of parents who were in a segregated system. When they hear this idea of we're returning to a meritocracy, my parents and my in-laws, their question is like, when was that?
Right.
when did we really have this merit system? Because they were born into a segregated system that was then eradicated with the law. But now are our practices consistent with that lofty objective? And I think that's what we're wrestling with now. And then that tension back and forth. I usually talk about it being a pendulum swinging, right? The pendulum was here. We can all acknowledge that we did not have a fair system, that there was sanctioned discrimination on the basis of all of those categories. And then the pendulum swings, okay, now we're trying to eradicate that. And some people believe that our efforts to eradicate that have gone too far and the pendulum swung too far the other way. And what we're trying to do now is sort of find that balance.
Mm-hmm. And I think that frames where we're coming from really well. And I guess the thing I would add to that is, so while in those days, maybe we were talking more about race in the form of equality, today it's moved beyond race into lifestyle preferences, all these other things that are very much headlines or real issues that employers are dealing with. And it has created a very tangled web, I think, with the new executive orders and memorandums signed as to what do we do now? Mm-hmm. And have we gone far enough today? And Fred, I know you work with many employers in this space as to kind of what do we do now? And I'm hearing some employers say, great, we're not going to do an affirmative action now. An affirmative action plan. I'm hearing other employers say, no, we're going to continue to do that. First thing I'd like to do is just establish the risk going forward. If I wish to continue to do affirmative action plans, or I would like to start to do one if I'm a private employer and haven't been required to do one. Any legal perspective on that? On the risk of continuing to do affirmative action plans if I'm a federal contractor after 60 or 90 days, whatever the grace period here is.
Yeah, I think that it's very clear under President Trump's executive orders that he did rescind Lyndon Johnson's executive order establishing affirmative action for the first 90 days. Federal contractor employers continue to voluntarily comply. But I think it's pretty clear that after 90 days, affirmative action is dead, assuming this executive order actually goes into effect roughly 90 days
Something
from now.
Doesn't change between now and then.
Correct. I think that we're likely to see some litigation.
So what I think I'm hearing you say is, if you are tied to federal funds, continuing to do an affirmative action plan is going to come with great risk of those funds.
Yeah, I think that's a fair statement.
Right. And Fred, one of the things that you and I chat about with that is, but what about our culture, right? I mean, we're used to, we have, 60 years of practice in these organizations that are, filled with people and filled with the culture of affirmative action, diversity, inclusion. What do we do in that space. So we take this thing, we take it off the shelf, we put it away, we don't have our hiring objectives that we used to have. How do we move forward in a time like that?
Well, I think we move forward carefully, but we move forward. And I think that's the crucial thing. Organizations need to attract and retain the very best possible candidates that they can. In order to do that, you need to have an extraordinary culture. To have an extraordinary culture, it is about treating everybody well, everybody in a way that they believe that they matter and that they belong. So if you want to talk about inclusion, how do you create that kind of culture? And that's what I think leaders that I work with are wrestling with. How do we create a place that, first of all, attracts people, and when they get here, they feel great about being here? It's one thing to bring people in. It's another thing to keep them, but to have them there and feeling that this is a wonderful place. And if we speak about it, where our current efforts have gone wrong is that we've fragmented organizations. We've created and solidified divisions rather than bringing human beings together. So we really have to rethink what we're doing, but we have to keep doing it. And that certainly is my advice. Obviously, it has to be done legally. So we have to recognize it.
The employers that we seem to work with through AIM, we measure this in the form of employee opinion engagement. We really work with, we do a lot of affirmative action plans and have done that, but that's not the goals and objectives we're usually working from. And Luther, you said it in our pre-warm up here, it really is about measuring the sense of inclusion in the workplace, the sense of belonging, the sense of, am I being treated fair at work by my coworkers, my leaders, the organizational policies? Very few times are we really dealing with affirmative action issues when we're working with employers. We're talking about much deeper rooted issues that make your workplace unique and hopefully get that engagement that gives you an advantage. And that's what I believe employers are saying when diversity is the center of our advantage, or it gives us a strategic advantage. I think those are the things that they're referencing, and to do that. Now, how you do that, I think, is the tough part. It's not easy in that sense. Burt, you look like you want to say something.
Yeah, no, I think that's right. It's not easy at all, and I think that kind of going back to the law in this area. Is it's been rebranded probably in the last certainly 5 years, but probably maybe going back 10 years. The goals of affirmative action, certainly in the private sector, kind of got somewhat rebranded as diversity, equity, and inclusion. I think it's certainly broader than affirmative action. It's a broader policy goal. It's a broader set of activities. But the branding of DE&I really caught on. Yeah. And, Phil, on our program, we've talked about it a lot, that I have suggested to employers that DE&I, if an employer wants to go down that road, they need to be very careful about it. And the reason is because we go back to Title VII that says that an employer may not make decisions because of an employee's protected status. And so if a company is using their DE&I program to make decisions because of a person's protected status, they are taking a significant risk that they are going to run afoul of the law. Yeah. Title VII as it exists today would say that if you are establishing any type of quotas, or if you're excluding any employee based on any protected class, in order to advantage another employee in a different protected class, that something like that would be illegal.
And we saw this first in the most glaring way, most recently in universities.
Well, the universities went after the admission, those cases went after the admissions processes, but immediately all the lawyers around the country, and that you're talking about the Harvard case, all of the people in our firm immediately got together and said, when the Supreme Court said that you may not have race-based admission criteria, the next thing that's coming is you may not have race-based employment criteria.
Sure. Makes sense.
Because Title VII says you cannot do that. And so we've talked a lot, again, as we pre-gamed here, what does that mean? What has diversity, equity, and inclusion sort of taken on a life of its own in some circumstances? Do people who are implementing diversity, equity, and inclusion, do they really know what they're doing? Because the exact type of behavior that they're hoping to eradicate with DE&I, they're actually in some circumstances promoting that same behavior just in a reverse manner. And so Luther and I were talking about it. I mean, I think that you said it great when you said that a lot of people, to the extent they're using DE&I to make anyone in an organization uncomfortable, it's not working correctly.
Right. And when you talk about the Students for Fair Admissions versus Harvard case, one of the interesting things about that opinion, which is distinguishable from every other opinion, is that the stated goal of the university in terms of having some kind of consideration of race was for the purposes as articulated by them, being diversity, equity, and inclusion. In every other case, the goal had been to eradicate and remedy the effects of past discrimination. And I think what the court said is, look, if you're taking race into consideration solely for the purposes of diversity, equity, and inclusion, and it's not tied to some sort of historical and admitted discrimination by your organization, that's problematic. And for me, especially as someone who trains in that space, I always talk about the conflation between DEI and affirmative action. The first thing that I always say is those are two separate things. And if you're taking affirmative action but calling it DEI, that's when you're going to have a bunch of risk. But when you are in the way that I talk about diversity, equity, and inclusion as a culture driver, as a retention device, as a way to improve the entire organization for every single human being that works there, right? We're not having that same sort of conversation. But I think a lot of organizations conflate that and they put it all under this umbrella of diversity, equity, and inclusion. And that is what causes the problem. And that existed before the executive orders from President Trump. But I think the executive orders are the manifestation of that conflation and that inability or unwillingness to be clear in what we are actually talking about within the organization.
Yeah. And Fred, did you?
No.
Yeah, no, I think I like how you frame that, Luther. It's DE&I has taken in a life of its own. It's gotten a lot of momentum in the workplace, and that I think intentionally meant to be for the better. That was always probably the core intention. And then I think it takes this momentum, and as you say, that pendulum swings. At that point, I start seeing workplace practices sometimes that feel forced upon people. And that's where I think many employees struggle when things are forced upon, when we have initiatives at work such as, and I'm gonna check this one here, Black History Month. And at the workplace, you see posters, you see things like that. And that aggravates sometimes white people in that sense. Whether it should or shouldn't, I want to go there, but I think it's a very delicate balance. And Fred, when you're working with employers, how do you help guide them in what's the right way forward? Because it's going to start with where they're at, I'm sure, but that's a difficult place of starting.
It is a difficult place, and I think you have to just be clear about what your purpose is, what it is, what are you trying to accomplish. You said earlier that it's simple or it's not simple. I would say that what organizations should be doing actually is simple. It is simple, but it is not easy. It is simple.
I like, the name of my book is Simply Complicated.
That is exactly right. It is simple to see human beings and treat them as human beings. It is simple to get beyond fairness and respect and equity. It is simple to say we want to have an extraordinary place for our employees to work. That's simple. Helping people actually see each other as human beings and work well with each other, though, that's the hard part. That's the culture part. What organizations do in this field is they come up with a commitment statement, they change some policies, and then they do some activities. The great failure is that the culture doesn't change. Culture doesn't change through policy, it doesn't change through training, it doesn't change through pronouncement, and it certainly doesn't change by forcing, coercing, shaming people if you in fact can't get the bulk of the employees to want to be able to make a change, then your culture doesn't change. We're confused when we believe culture is what we say it is. Culture is something that you experience. You walk into an organization and you know what the culture is, and you know it through the behavior of employees, not through values on the wall, not through how many DEI things you do per month or anything else. How do people here treat each other? The idea that we wouldn't be able to measure what comes from DEI is preposterous. Of course we can measure it. We measure it through satisfaction, through engagement, through retention, all the things that we talked about this morning.
Those are the importance of measuring those factors and then recognizing that's who we are.
That's the beginning. Who are we as an organization? Do we care about people? If we harden the silos of difference, which is what DEI does right now, it separates people more. Any effort that fragments organization is failing the organization. So for leaders out there to start thinking about, do we want to get rid of it? No, we don't want to get rid of it. We want the best culture we can possibly have. And to do that, we've got to attract and retain great people, and we've got to cast a much wider net to find them. You got to get people. You got to be a place that's a destination for me to feel that I belong.
Right. Absolutely. We're going to talk about something here, and as I do that, I just want to remind our audience, you can access an EEOC checklist that we've made available for everyone who is attending today. You can use the QR code on your screen, Nick. I'm sure that'll be on the screen for them. And that should help guide you through some of this next elements of our conversation. Let's talk a little bit about what you said. You can put the statements on the wall, you can have it in your handbooks, you have your job descriptions, your policies. What should we be concerned with today that could be written into those channels that could cause us problems, such as diversity statements? And I'll start by this, because this is a common question. Should I still use the EEOC we do not discriminate for statement in my job ad?
Yeah, I think we are in the job ad and on the bottom of the application where employers we are an equal opportunity employer. Absolutely, you should have that on there. That is still lawful. It's been that way since 1964 or whenever the EEOC was established, but you definitely, we all want to be an equal opportunity employer. That's what Title VII requires. Yeah. We have to provide equal opportunity to the employer. So yes, that should be on there. Now, when employers go a step further and they say we are an affirmative action employer, especially in the private sector, right now I think that's a little bit in flux, because whether a private employer, the Supreme Court has held that private employers can have affirmative action programs, that it's lawful for them to have those programs, but they need to be done very carefully. And so if you are a private employer and you are still having an affirmative action plan, you just need to make sure that you are not using that plan to exclude other people or preference certain people. So I would suggest that you be very careful if you continue with an AAP in the private sector, and if you are collecting data about race and gender and those types of things, that you do it, that it should absolutely be voluntary disclosure by the employees, and you just don't want to establish any sort of system where you're seeking quotas for people.
Does statements like, so think of that EEOC statement, we're all familiar with it, we've done it, and then a statement like this that's like tagged right to the end of it. This is common approach, right? Because then we try to express our culture then following that. And then we say something like, we're an equal opportunity employer, we got our statement, what we don't discriminate against, and then we say something like, we believe diversity strengthens our workplace and drives innovation. Right? Probably safe to say, but is that also a cue that, well, if you believe that, then are you purposely hiring for that? And is that in and of itself a form of discrimination?
I don't think so.
Yeah.
No, I don't think so either, but I think that question raises a really good point. And then when I'm doing training with a client, I usually start with their diversity statement. And then I ask them to be specific and articulate what that means at the end of the day. To me, and I think for the vast majority of people that are in this space, diversity encompasses a lot more than just the protected categories in Title VII. We want people from different parts of the country. We want people with different thinking styles. We want people that have had military experience.
Can speak different languages.
People that can speak different languages, all of those things that are permissible. And I would make the point, and Burt told me if you agree, the executive order is going to have some additional language that comes out sometime in the next 30 to 90 days. But it is very particular to say illegal DEI, not just DEI, but it says illegal DEI.
It does say that.
And I think part of the conversation that's going to happen is, well, what is a legal form of DEI? Because I think the executive order purposefully said, right, there's illegal DEI, which means by definition it has to be legal DEI. And if we look at Florida, which had a law that's very similar to the executive orders, Florida's law that has since been struck down on First Amendment grounds talked about indoctrination, trying to make people feel guilty or shaming them or whatever. And I think you're going to see a lot of that same sort of thing based on the executive order that we've seen now, and going back to President Trump's first administration when he had a similar executive order talking about DEI. I think there's going to be an articulation of, hey, these are the things when we say illegal DEI that we really mean. And I think the vast majority of people in this space will probably say, I agree. I don't want anybody doing that either. I don't want you to be indoctrinated. You mentioned Black History Month a moment ago. I can have a program, but you don't have to go. It's voluntary. And a lot of, when we looked at the Florida anti-woke law, it was, hey, you can't make it mandatory. But if you want to provide some opportunities for people to express their culture or have a program, you can attend, you can be a part of it or not. And it doesn't matter to your employment. This is something that is designed to enrich our organization. And so I think we're going to see that kind of conversation coming.
And I certainly
go ahead, Fred.
Certainly agree with what Luther said just now. Those things were going to go away anyway. We didn't need new executive orders. They were going to go away because they simply were not working. They weren't bringing people together. Organizations that have non-mandatory DEI, which of course they should all have, only have a small percentage of people participating in these programs, because the truth is most people don't actually support them. Not everybody is against them, but they don't support
That's a
them.
good point.
And that's a very,
That's the most
very
that is the
important
crucial
difference.
thing.
That's right.
That's crucial. If you have bystanders, and most people are bystanders, they don't change their behavior. And if their behavior doesn't change, your culture doesn't change. You got 10% of the people who are in the choir. Let's do this. You got 10% of the people who hate this. This is the most terrible idea we've ever seen. I do want it to go back to 1950 in the way you think of 1950. But the vast majority of the other people are saying, yeah, I think we should treat everybody fairly. It should be, but I shouldn't be forced to feel bad. I shouldn't be aggravated. I shouldn't have to go and learn about anything that I don't want to. I have a job to do.
Sure.
Those things were going to change, or DEI was going to die without executive orders, because we're not producing the kind of results that would have organizations continue to pay that
You know,
of
I
money
think back to a
do.
time when I was practicing HR, and we did employee opinion engagement surveys. We had diversity programs, which were very interesting. I'm going back 10, 15 years, and what that meant then at the workplaces I was at. And it was interesting because very few people really participated in our programs, but our surveys always were gleaning that they were treated fairly. They were treated with respect. So if I just said, well, what's happening with my diversity program, because it was popular for us to have it, we were trying, we wanted to make a difference. It was like, well, hardly anyone participates, and if they did, it was just people of color and me. And then you do a survey, and it's like, no, everyone felt really pretty good about the way they were treated and respected at work, and that was a much better measurement. Because I had my head down, because I'm like, well, where's everybody at? And it wasn't their gig.
Well,
the program wasn't their gig.
In following up, Fred, I think you said it absolutely beautifully, kind of summarized everything there. And then Luther, I think you're exactly right what you said. The executive order does use the term illegal DE&I. And so, that would kind of presume that there is a way to do this lawfully, which you and I have been suggesting, and Phil, we've suggested on the program, there is a way to accomplish the goals of this in a lawful manner. You just can't use DE&I to exclude certain people and prefer other people. And to the extent DEI is doing that, that's a problem. I do want to touch base or make a point that Luther mentioned it, I think, before, that just yesterday there was a new lawsuit filed challenging the Trump administration's executive orders challenging or targeting diversity, equity, and inclusion, both in the private sector and at the federal level. The lawsuit filed in the Maryland federal court, it was filed by a group of plaintiffs, including diversity officers, professors, and the city of Baltimore. And it argues that the executive actions are unconstitutional and unlawfully threaten organizations with the loss of federal funds. And so it's specifically challenging Executive Order 14151, which was the Ending Radical Government DE&I Programs and Preferencing, and Executive Order 14173, Ending Illegal Discrimination and Restoring Merit-Based Opportunity, which we've already discussed means one thing for one set of people and one thing for another. I think we know what it means going forward, merit for everyone. The plaintiffs in that case, they claim that the orders violate the First Amendment by restricting constitutionally protected speech and are unconstitutionally vague. And so it just squarely hits on what you said about the Florida law, that it was challenged on First Amendment grounds. And so I think what you said, Fred, is a lot of this was going to die anyway because it wasn't accomplishing what it was supposed to accomplish. And it certainly wasn't being implemented by a lot of companies the way it was supposed to be implemented. So I think kind of shifting gears a little bit, what do we do going forward? What does this look like going forward? And we joked at dinner last night, and this will show my age, and by default your age, because we're within a year of each other. I've always told employers that DE&I, to really do it right, if you sort of think of it in terms of what they used to say in the 80s, which you don't diss people, you don't disrespect people. And that's where I'm showing my age a little bit. But you treat people with respect. And if your goal of DE&I is to treat people with respect, and that's how you're going to establish the culture. When people are respected in the workplace, they feel good about their work environment. They may not like the work itself. Nobody, some people love what they do, but not everybody loves what they do. But they should be able to go to work and feel respected and valued. And so, what is the role of DE&I, or whatever it ends up being called, in that space going forward? How do we do this lawfully? And how do we attract that wide, how do we cast that wide net? What are some examples of that?
I don't think you get there through respect. You don't get there through equity. You don't get there through any of those standard ways. When people think about what inclusion means, it's that sense that I belong here. I belong. That is well beyond being treated fairly. And so, yes, I'm in an organization and I'm treated fairly, and I'm going to leave tomorrow if I get a better offer because they will treat me fairly there.
I would tell you, I always felt like I belonged at home, but I wasn't treated fairly at home. My brothers were always treated better than I was.
You were talking about when you were a kid, not with Angie right now.
Well, that's probably even more true. We do have a hierarchy of the kids and my wife and then the dogs and then me.
Angie, are you listening to this program?
Yeah, that's right. Yeah.
You're in trouble.
That's right. Belonging and inclusion, those are how people feel. Those are conditions. And we either feel included, we feel that we belong, or we don't feel that we belong. If we want to cast a wider net and retain and attract great people, you got to have a place where when you come there, it's more than coming to work and getting a seat at the table. I don't want to just sit at your table. I don't want to sit at your table and have a voice. I want to be part of an organization around people that care about me and that I care about them, where I'm treated, I believe my leader knows me and cares about me, a place where I have opportunity, where I can grow. These are the conditions that create inclusion. They happen through the acts and actions of leaders and all of the people around us. Just showing up at work, I would say it's table stakes to be treated fairly.
Right. And all of us train leaders, right? I mean,
train
we all do a lot of training and work with leaders. It's not always natural for people who are being given the role of leadership to be conscious. It's not natural always. There's some people that automatically do it, but there is almost as many that don't know how to demonstrate it, even if they feel it. And I think that's the importance of training and education and continuous practice. And what I mean by that is you have to train again.
That's the work.
That's the work, right?
That is the work. Absolutely.
And it doesn't happen because we dip train someone in a 2-hour program, 4-hour program, a 4-day program. That doesn't then produce the product.
Culture changes over time. It doesn't change because of a training initiative. It
you got to
changes.
Do it. You got to help them, educate them,
and do it,
and do it again,
and do it some more. And that starts with leadership saying, "Here's the culture that we are aspiring to have, and here's what it's going to look like." It is not a culture that's fragmented. Yeah. We don't have groups of losers. We have employees connected to other employees, and if we're teaching anything about group, we're probably losing. If we're dividing, fragmenting, and alienating people in this organization through what we're doing, we're absolutely losing.
That's beautifully said.
I think that's well said. And then the other thing, I've been consistent with what you said. In my training, when I come in, it's like, look, we're trying to get our DEI initiative off the ground. How do we do that? The first thing that I say is it's got to be customized to your organization. But what makes your company tick? And let's start to rally around that. And giving you a specific example, I had one client, they were really struggling, they felt fragmented, but they were like, everybody in our place, man, they love to eat. And so then they started incorporating different cultures in terms of food. And one of the things that started to build the culture was you had different food trucks that the company would hire. Yeah. And then folks would have, one day it might be Italian food, one day it might be Mexican food, one day it might be soul food. And people started to have natural conversations around a shared passion. We love to eat in our establishment, and we're going to use that as part of our strategy to unite people and bridge gaps. Seen that with
music as well.
Seen that with music. And so I said, look, let's design a DEI initiative and program that is consistent with who you already are.
It's inviting.
It's inviting.
From the beginning. It's inviting from the beginning. I do want to remind everyone they can access the EEOC checklist on the QR code on the screen. Gentlemen, let me ask you this.
Phil, real quickly, but the questions aren't loading properly here, but they're coming up sporadically.
Go for it.
And I know Janet, longtime listener and a client who I know, she asked the question, I'm going to hopefully get it right because it's not displaying on my screen, but she said that they're a federal contractor and the prime contractor sent something to them asking them to certify that they don't operate any DE&I programs, or they're not doing anything in violation of the executive order. And so her question is, I thought we had 90 days to comply. What are we supposed to do? And I think, Janet, if your prime contractor wants to cease these efforts right now, I would follow the lead of your prime contractor. But keeping in mind that we do think we're going to see some challenges to this over the course of the next probably, 80 days now.
Yeah, sure. And there are other affirmative action plans that we must still do, right? So we have veterans,
yes,
and people with disabilities.
That's right. It did not.
Yeah.
It did not take away.
Those are laws versus executive orders, right? So it's going to take a act of Congress to change that necessarily, I would assume.
Yeah.
I don't know.
And you'll notice in the executive orders when they start to articulate the things that are potentially illegal DEI, those categories are not mentioned.
That's correct.
That's right. Yes.
And I don't think age is in there either.
It's not.
So I think we're going to have this conversation around what does illegal DEI mean. The advice that I'm giving folks is I can certify to you that I do not engage in any illegal DEI. But I think you can make that certification as long as it's true. And I think for the vast majority of people, at least the clients that I work with, right, we draw those distinctions between EEO, affirmative action, and DEI. And I think that's going to be the pathway forward once we see some deregulations or court challenges or what have you. If we're really being true to the principles of how I define diversity, equity, and inclusion, then this conversation about being illegal never happens. I think the real problem and the real struggle has been, what are we actually doing, and are we being clear and articulating exactly what we're doing? Are we using DEI as a banner for a whole bunch of things that shouldn't be included under that particular banner or that moniker? And I think that's going to be the struggle, regardless of how this situation turns out with the executive orders.
So, Luther, let me ask you a question. What are those things that shouldn't be included in a DEI program?
Right, and I think you hit on a bunch of them. I think if you have quotas, if you have timetable goals that say, hey, we want to raise X population to this percentage by this date, I've always advocated, well before the executive orders, that that's going to cause you problems. If you are using DEI for the basis of racial preferences, that's the SFFA versus Harvard case. If your stated goal in having an affirmative action program is for the sake of diversity, equity, and inclusion, I think that's when you're going to run into some significant risk. Mm-hmm. And so I think it's, and I said this before we came into the room, the goal that I love in DEI is we want to be better today than we were yesterday. And I think you're going to have some goals that are very broadly defined and are very inclusive, and not having numerical targets, quotas, hardline dates or percentages.
I think if I was breaking it down, I said, look, we got to cast a broad net in our hiring practices. We need to make sure that our policies and procedures within our handbooks, our job descriptions, and so forth are not excluding people, because we require education or qualifications that aren't necessarily tied to the ability to do the job. And one way to look at that is who's doing the job already today, and what qualifications do they have? And if they don't have a college degree, but I require a college degree, then am I excluding it? I think that's taking care of itself, because people are having a hard time hiring. And so they naturally are been lowering that threshold as an entryway into, but that net has to be cast wide. That gets solved a lot today, because we all go to the same places to look for jobs today, differently than, well, you didn't read this newspaper and I only posted it in the pub at the corner, and the things that we used to have problems with maybe in the past. So those things, again, naturally start to resolve itself. Then we get into measuring. I'm going to just go back to, if we're not doing some form of measuring the workplace inclusion through employee opinion engagement surveys or other tools or methods, that's our best way to know, are we achieving success? I think you can still look at your demographics and go, is there something wrong with what we're doing? Because our community is 50-50, and where we live, but we're only hiring 80-20. And we can use that as a guide to understand maybe we're doing something wrong and look into our policies, but not establish quota.
Right. You can do that, and you can also use demographics even as you survey. If you use demographics as you survey, then you can look inside of your population and see if there are some groups that are being treated in ways where they don't feel included. So you may have a population of frontline employees who only answer the phone. Mm-hmm. If you look at your scores there and they are significantly lower, it tells you as a leader in that organization, there is something that we need to do. If you look at this population or that population, if you are measuring it, you can detect where you have issues and problems.
We have a question from YouTube here that just says, how do we make it more clear, as you've kind of said, that DE&I does not equal affirmative action? That's a good differentiator. We've been talking all about it. Any other ideas on how you make it clear one is not the other?
Yeah, from my perspective, and I do it in my training all the time, I continue to say that and explain what affirmative action is and explain what DEI is. Anyone who's ever sat through any of my trainings, they know that a lot of times I start off with that because I'm like, I want to make sure that we are defining our terms and defining our objectives, because if you keep obscuring that, that's one of the drivers of the division.
If you're using the phrase internally in a universal way, like we use pay equity and pay equality, it's two different things.
Absolutely. And so I think there's a big educational piece that has to be considered here in terms of making sure that we're making those distinctions. And then, at least and consistent with what you said and the EEO checklist that you have, making sure that the people that are hiring have been trained to be good interviewers and good ambassadors, right? Because sometimes people confuse that in the whole process, whether it's hiring into the organization or promoting people. And so we got to make sure that folks are being very clear in what the objectives are, being very clear in what they're talking about, and they're not confusing those concepts. Because when our leaders and our hiring officers confuse those concepts, then it is confused throughout the organization.
Yeah, I like I would emphasize that training for the interview process, right? We all will still have unconscious biases that might present themselves, and we're not even aware of that. But it is still amazing today when I sit in on interviews and help different organizations, the questions I'll hear people ask, and I assume they know better. Right. They assume they know. Don't ask that. Well, why did you ask this person that question and not someone else? Right. So it goes back to training, education.
There are a couple of other things to consider. Ronald Reagan once said, if you're explaining, you're losing. Part of where this
Are we losing right now?
Yes. We're explaining what DEI means.
Yes.
We're explaining it over and over and over again. We're trying to define. People have already decided what it means. We are losing if we continue to fight that battle. I mean, not because we need to, not because we have to, but we're losing. They've decided what it means, and it's not something that they want right now. Maybe we should think a little bit differently about this.
Phil, you brought up something, and I want to touch on it because we talked about it at dinner last night. Luther and I have done some work for the same client many years ago. No, not that many, I guess 4 or 5 years ago. Right. They were getting some rumblings of some union talk at the facility, and so Luther went in. He did an employee engagement, employee satisfaction surveys, and interviewing employees, and lo and behold, a couple years later, exactly what Luther had found, they got a union petition. Now, we were able to defeat the union petition, but I want to talk a little bit about what happened there. You had about 20% of the workforce that was turning over every few weeks. And we're talking about a couple hundred employee plants. So that's a significant number of people. It was like a revolving door. And the 80% of the people who weren't turning over, they were getting killed on work. They were getting killed on overtime. And Luther found something very, very important there. Most of the jobs in the facility, except in a chemical room and a R&D lab in the facility, you don't need a college or advanced degree. And what did you?
If I remember right, we even said it wasn't even a high school diploma.
Well, that's
required.
what did you find?
Right. And so as we started to think about this idea of casting a broader net, because they were having a problem of just having enough bodies, one employee said to me, as part of the climate assessment, I know our company would never do this, but I think we should waive the high school diploma requirement. I know a bunch of folks who would apply here, and they would be great workers because we can make good money and you can get a lot of overtime. But they haven't applied because you say that you have to have a GED or a high school diploma. And this was in a very rural area where probably a good percentage of the population didn't finish high school. And they removed the criteria, and guess what? Now you had a bunch of additional people that were applying. And part of this conversation around DEI, at least the way that I think about it, is when we, especially the E, when we talk about equity, we're removing those barriers that would stop us from being successful. And that was a requirement that you didn't have to have. You did not need to have a high school education to do the vast majority of the jobs that were there. And the company looked at that and said, you know what, let's remove that requirement and see what happens. And they were able to attract more employees.
A lot of organizations are really looking at that right now. What are we doing, not intentionally, to exclude people? That's a perfect example. We are excluding a whole population who can do this work, but we're not thinking about it. So those are structural things. We still need to continue those in DEI work. How are we excluding? But how we include is not by giving them a job. That's the changing of the culture.
Okay.
Phil, can Jennifer, who's listening, following us on YouTube, she says that creating the culture comes with having some self-awareness, conversations, / leadership development with leaders that has fallen under the DE&I programming umbrella. And one of the things, kind of the method to the madness, one of the things that we're hoping to do with the program today, yes, we're talking about what the law is. We've talked about the policy goals behind the law. We've talked about the pendulum swinging. But one of the things that we've also done today is we have had an unbelievably great conversation. 2 white guys, 2 black guys sitting here together talking about these very sensitive issues in the workplace. We've done it respectfully. We've done it thoroughly, and we've hopefully given people some education on how to have these conversations. Again, part of the method to the madness is just watching us have these discussions with one another. And I think that what you see, and it gets to what Fred said, we haven't compartmentalized anybody. We haven't divided anybody in here. In fact, we've probably largely agreed on what DE&I should be. No matter what you call it, you respect people, you value them, they feel like they belong. That's what DE&I really should be. It shouldn't be excluding people to benefit someone else. And so hopefully the listeners, the viewers today have at least seen how people can engage with one another and have these conversations. I think if you take away nothing else, you've watched 4 people sit in here and have a very civil discussion on what is a highly charged topic these days.
It is charged, and it's charged because it's rooted with emotion, but it's also complicated. And I agree with your statements here, Burt. I'm glad that you made that statement. But there's still more for us to discuss before we say goodbye here. And I want to talk about just a few more like emotionally charged topics. They, them, all right, in the workplace. Man, I've heard as many people who favor that. I've heard as many people go, "What the heck is that?" and be opposed to it. For workplaces that I would say promote or allow that in their workplace, their systems are designed for. You know, you use an HRIS system. You go in, you put your own information, your data in, you self-identify your pronoun. The executive order is talked about boy, girl, male, female. Where does that line cross, if it does cross, into the private sector?
You know, from the program that I have encouraged employers not to wade in to this area because organizations are made up of all kinds of different people with all kinds of different beliefs. And anytime it just gets to Fred's point, anytime you start favoring one group or compartmentalizing another group, it's to the exclusion of a different group. And so I've encouraged employers not to wade into it. If they wade into it right now, in the private sector, it's by policy. It's by what the organization chooses to do, but recognize that it's going to come with difficulty one way or the other. If an organization waded into it and now they want to wade out of it, that's going to create a problem, which I would have said, don't go there in the first place. But if organizations did that, it's about communication. It's about clearly articulating to the group that wants the pronouns on the email signatures and the HRIS systems and all of that. It's delivering the message that we're not telling people that they can't support those types of efforts, but what we are saying is it's really not a workplace issue. It's that one's a little bit harder. I do think the Supreme Court.
It's a difficult one. That's why I saved it for the end, because we can cut the program right now.
And also, I think another point is that's really important in this space is you have to look at the organization itself. If you are a gym that has gym facilities or any type of a coal mine or a
shower facilities at work,
manufacturing facility where you get filthy during the day, and there's shower facilities and locker room facilities, that it takes on a whole different meaning about shared restrooms and those types of things. So these are very difficult issues. I think
if you're not tied to government money, whether it's the federal government money, your state government money, and for those who have state funding programs and state affirmative action programs, you still would follow those state guidelines as long as they weren't tied to federal dollars. But if you're a private employer, you have to do what's best for your customers and for your employees.
That's right.
And I think that's a good guideline. What's best for our customers and our employees, particularly when you talk about shower facilities, and access to children and protecting children, those types of things, from the views of what society is thinking and leaning. I mean, when you say protecting children, I hate to say that because someone's going to go, well, what are you protecting children from? I'm not trying to make that point. I'm just saying that there's an expectation that you're protecting children. And how do you meet that expectation at a workplace, a place of employment where customers are interacting, right?
There was a very tough lesson learned by a certain beer company that waded into that area and didn't necessarily take into account maybe they did take into account how their employees would feel about it, but they certainly didn't take into account the potential customer backlash. And so they dipped their toe into that water and then scrambled out of the water. And they're still reeling from it a couple of years later. And so again, these things need to be thought out carefully. In our field, in HR, but certainly in the law, Luther and I, we look at things 2 and 3 and 4 years down the road. How's it going to play out in court? What's it going to look like in front of a jury? And so when we advise clients, we always look at things. How's this going to impact things years from now? What's the exit strategy going to be? And I think organizations, they really need to be careful when they're dividing, compartmentalizing, doing things that are going to make some employees happy, but some employees angry, and deciding whether they want to be in that space.
All right,
great. Let's go around the horn. Any final thoughts here, Fred?
I think the final thoughts is that if you're dividing employees into groups, you are going to lose, you are not going to progress, and you're going to ultimately run afoul of the law, as well as have a program that doesn't work. You can't divide people into groups. Human beings, you've got to be able to see that, and your programs have to demonstrate that.
I'm almost at the point where I'm going to say I have nothing further to add because Fred said it so beautifully, but that's not me. We have to create a work environment where people feel respected, they feel valued.
That's right.
As Fred said, they don't just have a seat at the table, they have a voice that matters. And we need to build a culture where people feel united behind the goals of the company and stop trying to drag all of the politics into the workplace. You're never going to convince people to change, well, most likely not going to convince people to change their politics, change their preferences, change their whole belief system. But if you get them in the workplace and you say, we want you to believe in this culture, in this mission of the company, we live it every day, that's how you get belonging. And diversity, equity, inclusion, it doesn't mean excluding people, it means bringing everybody along on that mission.
Absolutely. Thank you, Burt.
Yeah, and I think my final comment would be, and I say this to employers all the time, and this is why I'm a fan of having a customized DEI program for your particular organization. We've been wrestling with issues of race equality, sex equality, and discrimination throughout our history. You're not going to solve that.
And around the world.
Around the world, yeah, that's fair. You're not going to solve that as an employer, but what you can control is what happens within the confines of your organization. And if we can be on the same page, if we can be clear in what we're doing. You had a question here about Black History Month, Asian Pacific Month, or what have you. When we can say, look, here's why we are doing what we're doing. It is not for the terms of indoctrinating. It is for the terms of supporting and having a celebration of cultures that make our culture so special. And if you're leading in that fashion and everybody's on the same page, a lot of these issues that we're wrestling with outside of the walls of the organization are not going to impact your culture. The failure is when we're doing things and it's not consistent with who we are. We've never celebrated any of these months, for example. And all of a sudden we're going to do it because we think it's the right thing to do. That's when you start to run into problems. And so I usually sum it up by saying, as an employer, we can heal the band. We may not be able to heal the land, but we can heal the band that's here and make sure that we're focusing on being the best version of our organization that we can be.
That's great.
I think I have nothing to add of that kind of context. You guys are so smart. I see so many of our friends joining us online, Burt, that follow us each week. There's Patty saying hello, and Fred, she absolutely loves you. Every time I see her, she tells me how much she enjoys listening to you. But I guess I would leave with this. I think it's about education and training in my mind. We can't assume people know how we expect them to behave and lead. And the more that we can educate people and train people over and over and over again, those are the workplaces that I see that are moving forward purposely by design, and they get it more right than they do wrong. To help with that, you can book a complimentary free hour session with our HR engagement expert, Tanya Zion. You can use the QR code on your screen to do that. Tanya couldn't be with us today, but I assure you she is right in line with the thinking that we have here. So I invite everyone, if you would like to have some time with Tanya and talk through these things more specifically. She also does manage our affirmative action plans and programs, so she can also have some insight in that space as well. And finally, I'd like to say thank you to producer Nick and our friends at Feature Group for bringing us into your studio and making this available to our listeners today. As always, if you ever need any special assistance in getting messages across to your employees and your customers, I'd highly recommend you reach out to producer Nick here at Feature Group USA. So I would just like to close out like I always do, which is thank you for joining. Burt and I will be back next week at 7:30 Central Time on Thursday. Until then, go out and be good to somebody.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please like it, share it, and make sure it's on your calendar. If you're an on-demand viewer, don't forget you can be part of the show by watching live at 7:30 a.m. Central every Thursday morning when you can get your burning questions answered by using the question mark icon to the right of the player. In fact, you can ask a question now. Head over to aimea.org. Under Member Resources, you'll find This Week at Work. Click Listen Live to register for our next episode and submit a question. Or follow or subscribe wherever you get your news and entertainment. We'll see you next week when we discuss what's happening this week at work.